Ever feel like one client is sucking the life out of your entire practice? If you're losing sleep over someone who's draining your time, underpaying, or pushing ethical boundaries, it might be time to let them go. In this video, I'm going to show you how to fire a bad legal client the right way, so you protect your license, your sanity, and your schedule. If you've ever felt trapped by a demanding or disrespectful client, you're not alone. And more importantly, there is a way out. Coming up in this video, I'm going to walk you through three key things. First, how to know when it's time to fire a client. Second, the right ethical way to do it. And third, how to protect yourself from backlash. By the end, you'll know exactly how to exit these relationships professionally and protect your firm, your reputation, and your peace of mind. What if you could walk into your office tomorrow and never have to deal with that client again? You know the one. They blow up your inbox, ignore your advice, push your boundaries, and make you question why you took them on in the first place. Imagine how much mental space you'd get back, how much smoother your day would run, how much more energy you'd have to focus on the clients who do respect your time and actually pay their bills. Firing a bad legal client isn't just about cutting ties. It's about reclaiming your practice. But if you don't do it the right way, you're not just risking some awkward tension. You could be opening the door to malpractice claims, bar complaints, or worse. Let me show you how to do it the right way. Let's start with how to know when it's time to make that call. There are a few big red flags to watch out for. Chronic non-payment, constant fee disputes, or the client always trying to negotiate your invoice after the work is done. Disrespectful or even abusive communication, emails or calls that cross the line into personal attacks or that treat you more like a servant than a professional. Clients who constantly push scope or boundaries. You agreed to X, but they keep trying to sneak in Y and Z without paying for it. Ethical red flags. Maybe they lie to you or press you to do things you're just not comfortable with. And one of the most overlooked signs, they start taking up more and more of your time, pulling you away from other cases, causing problems with staff, or leaving you constantly distracted. If one is hurting your ability to serve others, then that's a serious problem. Here's a tip. Keep a gut check journal. If you're venting about the same client more than once or twice a month, that's not a coincidence. That's a pattern. Note those things down in your file for future reference. Now that you've recognized it's time, let's talk about how you should actually do it the right way. Under the ABA's Model Rule 1.16, there are specific situations where you must withdraw from a case and others where you may, such as when the client persists in a course of action involving the lawyer's services that the lawyer reasonably believes is criminal or fraudulent, has used the lawyer's services to perpetuate a crime or fraud, insists upon taking action that the lawyer considers repugnant or which the lawyer has a fundamental disagreement, or fails substantially to fulfill an obligation to the lawyer regarding the lawyer's services and has been given reasonable warning that the lawyer will withdraw unless the obligation is fulfilled. But you can't just decide you're done and walk away. The rule states that the withdrawal of representation must be accomplished without material adverse effect on the interests of the client. If you're in active litigation, you'll probably need a motion to withdraw. Bottom line, always check your state's rules, not just the ABA's. Many times the language differs in subtle or significant ways. So how do you actually break up with a client? Here's the 4-step process. 1. Send a formal, professional written notice. Make it clear but neutral. 2. Give the client enough time to find new counsel. Don't leave them stranded. 3. Return all of their case files, any unearned fees, and anything else they're entitled to. And 4. Clearly state the date your representation ends. No vague timelines. Keep the tone calm and factual. This is not the place to vent or explain why they were a nightmare or to accuse the client of anything. If possible, take an "it's not you, it's me" position. Just keep it professional. Now let's talk about protecting yourself from the possible fallout. First, document everything. Every conversation, every letter, every step you took. You're building a record in case they push back later. Also, remember to review your notes in that gut check journal I mentioned earlier. Second, if you think the client might retaliate, you might want to consider notifying your malpractice carrier now. Don't wait for something to happen. Third, don't take the bait. If they leave you a nasty review or try to start a fight, don't respond emotionally and consider not responding at all. Stick to your ethical obligations and state bar rules, some of which limit what you can say in public responses. And finally, if they file a grievance or complaint, stay calm. Get help from ethics counsel or your malpractice carrier before you respond. Don't go it alone. So now you know how to fire a bad legal client the right way, ethically, professionally, and without putting your license or reputation at risk. But here's the truth. The best way to avoid the headaches, the stress, and the fallout is to never take on those bad clients in the first place. That's why the next step is just as important as what you've learned today. Watch my video, How to Spot a Bad Legal Client, where I'll show you how to recognize the red flags before they ever become your problem. You'll learn how to spot trouble early, how to decline clients professionally, and what to do if you've already let one slip through. You've just learned how to clean up a mess. Now it's time to stop making them in the first place.